Joshua Earrey, come with me.
Okay, I'm coming, but can you please tell me what for?
Joshua Grady Earrey dedicated 22 years of his life to being a Florida Highway Patrol trooper, the kind of career that earned him Trooper of the Year. The very profession that gave him everything would eventually take it all away.
1,000 pounds of evidence weed under your destruction signature.
Under my name? What does that mean?
If you just tell me which case I can pull up, every destruction log you signed across 3 years.
Are those handcuffs? Why do you
I said I would cooperate.
The Florida Highway Patrol called him Trooper of the Year in 2009. 16 years later, federal agents would walk him out of a Jacksonville parking lot in handcuffs. The investigation that brought them there had been running for nearly 2 years. 4,572 text messages, 3,164 phone calls, over 1,000 pounds of marijuana logged as destroyed but quietly resold on the street, a kilogram of cocaine handed to a drug dealer by a federal task force officer, and cases of Florida Highway Patrol ammunition traded to a convicted murderer in exchange for oxycodone pills. By the time it was all on the table, the man in this footage would be inmate number 16 in a federal courtroom in the Middle District of Florida, facing a sentencing range built on 22 years of betrayal. Quick question before we go deeper into this one. How many cases do you think one corrupt evidence room officer can poison before someone finally notices? Drop your number in the comments. And if you're new to the channel, hit subscribe. We cover the cases where the badge was the weapon every single week. Joshua Grady Earrey was born in 1978 in North Florida, into the kind of working-class family that took the idea of public service seriously. His father worked construction in Duval County. His mother worked the front desk at a doctor's office off Beach Boulevard. They lived in a small ranch-style house with a chain-link backyard and a screened porch where his father drank coffee before sunrise and read the Florida Times-Union front to back. Joshua was the second of 3 children. The neighborhood was modest, but it was the kind of place where the men who lived 2 doors down were sheriff's deputies, where the man across the street drove a state vehicle to work every morning, and where law enforcement was not an abstraction. It was a paycheck, a pension, a uniform you saw at the Publix on Saturday mornings. He was a quiet kid. Teachers at his elementary school described him in early reports as polite, attentive, follows directions well. He played Little League baseball at a public field on the south side. He attended a Duval County public middle school and then a large Jacksonville area high school, where he was, by every account, unremarkable in the best possible way. He did not get into fights. He did not skip class. He played right field, hit a solid .280, and graduated in the middle of his class in the mid-1990s. After high school, he did 2 years at a community college, took a few criminal justice courses, worked nights at a tire shop, and then applied to the Florida Highway Patrol. He was 22 years old when he reported to the FHP Training Academy in Tallahassee. The class photo from his academy session shows a young man with a buzz cut and a serious face. Second row, third from the left. His instructors evaluated him as reliable, physically fit, demonstrates strong situational awareness on traffic stops. One supervisor wrote that he had the kind of demeanor that calms a scene rather than escalates it. That phrase would follow him through his early career. He pinned on his badge in the early 2000s and was assigned to Troop G, working the highways and interstates around Jacksonville. His starting salary was just over $31,000 a year. He worked nights, he worked weekends, he worked holidays. He pulled drunk drivers off Interstate 95, worked fatal crash scenes on the Buckman Bridge, and ran radar on the long, flat stretches of US 1 south of the city. His sergeants noted in annual evaluations that he was a self-starter, shows initiative, a credit to the troop. By the late 2000s, he had a reputation inside Troop G as one of the troopers you wanted on a major crash. He stayed calm. He did the paperwork. He did not cut corners. He married in his late 20s. His wife worked in healthcare administration at one of the big hospital systems in Jacksonville. They bought a modest 3-bedroom house in a suburb on the south side of town, the kind of neighborhood with cul-de-sacs and basketball hoops at the end of driveways and American flags on most porches. They had children. The garage filled up over the years with the things a working father accumulates: a fishing kayak, a riding mower, a set of golf clubs that did not get used as much as he meant to use them, a workbench, a deep freezer for the venison his brother-in-law brought down from Georgia every November. In 2009, the Florida Highway Patrol named him Trooper of the Year. The award was for a combination of factors: a high-volume DUI enforcement record, his role in a multi-trooper response to a fatal crash on I-10, where he organized scene management in a way that earned a specific commendation from the colonel, and a string of arrest reports that prosecutors in the state attorney's office described in performance feedback as clean, thorough, and bulletproof on the stand. He stood on a small stage at an FHP awards luncheon, accepted a wooden plaque from the colonel, posed for a photo with his wife in a sequined dress and his small children in their Sunday clothes, and went back to his troop. He had been on the job 9 years. He was 31. The years after that award were the years of his rise. He picked up extra training. He worked on interdiction details on I-95 and I-10, the long drug corridors that carry product up the eastern seaboard and across the panhandle. He developed an instinct for what a courier vehicle looked like, what a recent rental with out-of-state plates and a single occupant driving exactly the speed limit at 3 a.m. probably meant. He made cases. He testified. He sat through countless suppression hearings in state court, and he learned the kind of careful, neutral testimony that holds up under cross-examination. By 2014, he had been designated as a task force officer with the Drug Enforcement Administration's Jacksonville office. The TFO designation meant he kept his FHP badge and his FHP paycheck, but he reported in for DEA cases, sat at a DEA desk, and held federal credentials. He was, in every functional sense, both a state trooper and a federal narcotics agent at the same time. He had access to FHP evidence custody. He had access to DEA evidence custody. He had access to federal wiretap rooms and confidential informant files. He had access to the kind of information that ruins a defendant if it walks out the door. Evidence custody inside a state law enforcement agency is built around one principle. Every item that comes in must be logged, sealed, stored, and accounted for from the moment it enters the chain to the moment a judge or a destruction order signs it out. In theory, that chain is unbreakable. In practice, it depends entirely on the integrity of the officers who handle it. The Florida Highway Patrol stores narcotics evidence at secured holding facilities. The DEA does the same at a higher level of physical security: vaults, biometric access, video surveillance, 2-officer rules on movement of high-value seizures. But there is a category of evidence that creates a gap. When a case has resolved, when the defendant has pleaded out, when the appeals are exhausted, when the prosecutor signs off, the seized drugs and the seized cash and the seized contraband are slated for destruction. Marijuana, the cheapest and bulkiest product in the system, gets destroyed in massive volumes. It is incinerated, usually at a contracted facility, with destruction paperwork generated at every step. A destruction event involves an inventory list, a transport log, a witness officer's signature, an incineration certificate, and a final record entered into the agency's evidence management system. Once a parcel is logged as destroyed, the system treats it as gone. Nobody checks. Nobody opens the bag. The paperwork closes the loop. The destruction process exists because nobody can store every gram of marijuana ever seized in Florida. There is not enough room. There is not enough money. So, the system relies on a very small group of officers signing off on very large quantities of product leaving the chain. In Jacksonville, the men who signed off on a great deal of that paperwork during the relevant years included Joshua Grady Earrey and his fellow DEA-associated officer, James Darrell Hickox. Hickox was a long-time narcotics investigator who had been working federal task force assignments for nearly as long as Earrey had been on the job. They knew each other. They worked cases together. They sat in the same task force room. They shared the same access codes. They had the same signature authority over the same paperwork. This was the gap. A signature from a senior task force officer indicating that a parcel of evidence had been destroyed was, inside the system, the equivalent of the parcel ceasing to exist. There was no audit on the back end. There was no double check from a non-task force officer. There was no requirement to film the destruction. There was no requirement to weigh the contents at the incinerator door against the original seizure weight. The paperwork closed the case, and the case closed itself. It is a system that works exactly as designed for 99 officers out of 100. The 100th officer is the problem. The 100th officer is the reason this story exists. Because for 99 officers, that signature line is a procedural formality. For the 100th, it is a license to print money in product form. The federal plea agreement places the start of the conspiracy in 2017. The sentencing fact sheet narrows the most aggressive period to 2021 through 2023. Either way, the pattern was the same, and the pattern was simple. It started with marijuana. Marijuana, in pounds, is the easiest product to move out of an evidence room because it is the most often destroyed. A single seizure can generate 20, 50, 100 pounds of product slated for incineration. A trooper assigned to manage that destruction had hours of unsupervised access to bales, bags, and vacuum-sealed bricks. The destruction order required a signature. It did not require a chaperone with a camera. According to the federal record, Earrey and Hickox stole more than 1,000 pounds of marijuana from FHP and DEA evidence holdings over the course of the relevant period. They removed product before it ever reached the incinerator. They gave it to a third party to resell on the street. They submitted falsified destruction paperwork to the agency's evidence management system, showing the same product had been incinerated as scheduled. It was not subtle. 1,000 pounds is half a ton. It is a quantity that, by retail street value, runs into 7 figures. It is a quantity that, by weight, requires planning, transportation, and a buyer who can move it without attracting attention. They had all 3. The buyer was a person they trusted and controlled. The transportation was, in some instances, the same vehicles they drove on duty. The planning was built into the destruction schedule itself. Then it escalated. They stole a kilogram of cocaine from evidence. A kilogram of cocaine, depending on the year and the market, retails on the street at somewhere between $20,000 and $40,000 wholesale, and significantly more if broken down into smaller distribution weights. Earrey handed that kilogram to a drug dealer to sell. That dealer kept a portion of the proceeds and returned the rest. The cocaine, like the marijuana, had originally been seized from someone whose case was still active in the system. Somewhere in a Florida courtroom or a federal courtroom, a prosecutor was relying on that evidence to exist. It did not exist anymore. It was on the street. Then fentanyl. The federal record states that Earrey and Hickox distributed fentanyl and cocaine to others for street distribution. Fentanyl in 2021 and 2022 was the single deadliest narcotic in the American supply chain. Overdose deaths in Duval County were running at record levels. The product Earrey was moving was, in some quantity, the same product killing the people whose deaths he had spent 22 years responding to as a state trooper. He had worked overdose calls. He had worked the death notifications. He had stood in living rooms in his FHP uniform while parents collapsed onto kitchen floors. And he was now putting more of the same product into the supply. The corruption was not confined to product. Earrey accepted money from drug dealers in exchange for protection from law enforcement. The federal record describes this as extortion and bribery, money paid by dealers who knew that the man on the other side of the table held a federal task force badge and that his cooperation could keep them off a wiretap, off a search warrant, off a confidential informant's list. He took the money. He provided the protection. The dealers continued to operate. And then came the trade that, more than any other, defined the case for the federal judge, who would later sentence him. Earrey diverted cases of ammunition from the Florida Highway Patrol, duty ammunition, the rounds that go into the magazines of working troopers, and traded those cases to a convicted murderer in exchange for oxycodone pills. A man convicted of homicide, prohibited by federal law from possessing a single round, received cases of FHP stamped ammunition delivered by a sitting trooper. In return, Earrey received oxycodone, 7 to 10 pills at a time, at $30 a pill, supplied by a federal task force officer addicted to his own surgery. The addiction had a date, January 2023. He had back surgery. He had been prescribed oxycodone, hydrocodone, and extended-release morphine across 43 legal prescriptions between May of 2018 and the morning of his January 2023 surgery. After the surgery, the legal supply ran out faster than the dependency it had built. He started buying from the street. He started buying from the people he was supposed to be policing. He started buying from a confidential informant who would, by the spring of that year, begin telling the federal government everything. The lifestyle markers that should have caught the attention of his supervisors did not. He drove a department-issued vehicle. He lived in the same modest house. He did not buy a boat. He did not buy a vacation home. The proceeds were folded into ordinary expenses, into pill bills, into amounts that did not generate a paper trail loud enough to trigger an internal audit. His sergeant saw a senior trooper with 2 decades on the job, a back surgery in his medical file, and a service record that had once made him Trooper of the Year. They did not see the rest. Nobody did. And that is the thing about this kind of corruption. It does not require a lifestyle change. It does not require a Maserati in the driveway or a watch collection or an envelope of cash in a safe deposit box. It requires only an officer with access and a willingness to lie on paper. The product moves. The paperwork closes. The audit never comes. Until one day, a confidential source picks up a phone and calls a federal agent and says the words that start the clock. We're about to get into the investigation now. If you've made it this far, you already know how this one ended. But the way the federal government walked it back, message by message and call by call, is the part of the story that does not make the local news. Subscribe if you want to see exactly how these cases get built. We do this every week, and the cases that matter most are the ones where the badge was the thing that made it possible. The catalyst, when it came, was almost mundane. A confidential source contacted the Department of Homeland Security and reported that a working federal task force officer in Jacksonville was buying oxycodone pills in volume off the street. The source named Joshua Earrey. The source described the pattern: 7 to 10 pills at a time, $30 a pill, a regular customer. The DHS report could have died in a queue. It did not. It was escalated to the FBI's Jacksonville field office. The FBI opened an investigation. The investigation was assigned to agents who specialized in public corruption, the small, quiet unit inside every major field office that exists for exactly this kind of report and for nothing else. What the agents did next is the part of the case that closed every other part. They identified the confidential source. They debriefed the source in detail. They built a controlled cooperation plan. The source, already in contact with Earrey, already buying and selling within the same circle, became a controlled informant in the federal investigation. From that point forward, every message between the informant and Earrey, every phone call, every meeting, was monitored, captured, logged, and time-stamped. The scale of the contact between the two of them was already extraordinary before the federal capture began. Once it started, the data multiplied. By the end of the investigation, the FBI had recovered 4,572 text messages between Earrey and the confidential informant. They had captured 3,164 phone calls. At one peak stretch of the investigation, contact between Earrey and the informant comprised 27.4% of Earrey's total phone activity. More than a quarter of every text, every call, every minute on the phone of a senior federal task force officer was being spent communicating with a man who was, by then, working directly for the FBI. The agents watched the pattern. They watched the buys. They watched the volumes. They watched the prices. They saw the dependency. And in the background, they were beginning to see the rest of it: the references to product, the casual mentions of paperwork, the hints of a co-conspirator on the federal side. In March of 2023, the federal government moved on the front end of the case. Earrey was arrested on a federal charge of possessing firearms and ammunition while being an unlawful user of a controlled substance. The arrest looked, on the day it happened, like a narrow drug case. A trooper with a pill problem, a federal possession charge built on the medical record and the controlled buys, a bond hearing, a pretrial release. It did not look, on the day it happened, like the front end of a corruption investigation that would eventually pull 22 years of evidence room paperwork apart. But that is exactly what it was. The narrow arrest gave the federal government the time, the leverage, and the access to keep building. The next part of the case was already coming. The investigation that followed the March 2023 arrest expanded in every direction at once. Federal agents pulled Earrey's destruction paperwork going back years. They cross-referenced the destruction logs against the original seizure inventories. They compared signatures, dates, weights, and case numbers. They built a parallel ledger. What the agency's records said had been destroyed against what the agents could prove had actually been incinerated. The gap was the case. Bag after bag of marijuana logged out of evidence as destroyed by Earrey's signature, or by Hickox's signature, or by both, with no corresponding incineration receipt. Quantities that, summed across the relevant period, exceeded 1,000 pounds. A kilogram of cocaine, high purity, packaged for distribution, recorded as destroyed on a date when the federal investigation could now show, through phone records and surveillance, that it had been physically handed to a street-level distributor by a uniformed federal officer. The text messages were worse than the paperwork. The investigation captured contemporaneous discussions of pickups, drops, prices, and counter-surveillance. References to law enforcement movements that Earrey had passed on. References to dealers he had specifically agreed to keep off particular wiretap targets. Confirmations of payments received. Acknowledgments of product moved. The messages were not coded enough to provide deniability. They were not careful enough to survive a federal subpoena. The pill buys were documented in granular detail. The federal record laid out, transaction by transaction, the 7 to 10 pills at a time pattern at $30 a pill, the dates, the locations, the intermediaries, the dollar amounts handed over, the pharmacy records that confirmed the 43 legal prescriptions Earrey had been written between May of 2018 and the day of his January 2023 surgery sat alongside the text messages requesting illegal pills from the informant immediately after that surgery. The legal supply and the illegal supply ran on a continuous timeline, with the illegal half taking over at the exact moment the medical taper began. The ammunition trade was its own document. Agents identified the convicted murderer who had received cases of FHP ammunition. They confirmed that Earrey had personally delivered or arranged delivery of those cases. They traced the corresponding flow of oxycodone in the opposite direction. The ammunition itself was federal property. Diverting it was a separate offense from the narcotics conspiracy. Providing it to a prohibited person, a convicted murderer, was another. And then there was the co-conspirator. The investigation that started on Earrey did not stay on Earrey. James Darrell Hickox, his fellow DEA-associated officer, his signature partner on years of destruction paperwork, came into focus. Agents searched Hickox's home. They recovered 263 grams of fentanyl powder. They recovered cocaine. They recovered evidence consistent with personal distribution and tax evasion patterns that would, in time, support an entirely separate federal indictment. The smoking gun, the single piece of evidence that closed denial, was the falsified destruction paperwork itself. Hundreds of entries across the relevant period, each one signed by a federal officer, each one certifying that a parcel of evidence had been incinerated as scheduled, each one a lie under signature in the agency's own system, by the agency's own people. The same paperwork that was designed to keep evidence custody honest was the paperwork that proved the case once federal agents pulled the file. There was no plausible explanation. There was no clerical error defense. There was no way to argue that 1,000 pounds of marijuana and a kilogram of cocaine had been incinerated by accident in the wrong building. The signature was the case. By the time federal agents sat across from Joshua Earrey to walk him through what they had, the investigation was already complete. The text messages were captured. The phone calls were captured. The destruction paperwork was pulled. The pill buys were documented. Hickox was already being worked. The cooperators were already cooperating. The agents laid it out. The transcript of the proffer stage conversations is not public, but the federal record describes what the government had on the table. The numbers were specific: 4,572 text messages, 3,164 phone calls, 27.4% of his phone activity, 1 kilogram of cocaine, more than 1,000 pounds of marijuana, 43 legal prescriptions, the ammunition trade, the convicted murderer, the bribes from dealers, the fentanyl pushed into a city already at peak overdose. "You understand what we have," one of the agents said, in substance. He did. He had spent 22 years on the other side of that conversation. He had run it on suspects. He had run it on his own confidential informants. He had run it on the people whose evidence he had stolen. He shifted in the chair. He looked down at the table. He answered some questions. He stopped answering others. He asked for his lawyer. His lawyer arrived. The negotiations began. The terms of the plea were not generous because the case did not require generosity. The government had everything it needed. The defense had two arguments: the addiction and the 22 years. Both would matter at sentencing. Neither would matter at the charging phase. The federal grand jury returned an indictment that included, by the time the case resolved, 3 counts. 1 count of conspiring to distribute narcotics, carrying a 5-year mandatory minimum and a maximum of 40 years. 1 count of conspiring to defraud the United States, the falsified paperwork count, with a 5-year statutory maximum, and 1 count of possessing firearms and ammunition as an unlawful user of a controlled substance, the original arrest charge from March of 2023, now folded into the larger case. The combined statutory maximum exposure across the 3 counts was 60 years in federal prison. On April 4, 2024, Joshua Grady Earrey stood in federal court in the Middle District of Florida and pleaded guilty to all 3. The sentencing came almost exactly 1 year later, in April of 2025. United States District Judge Wendy W. Berger presided. Assistant United States Attorney William S. Hamilton, on behalf of United States Attorney Roger B. Handberg, presented the government's sentencing position. The investigation was credited jointly to FBI Jacksonville, IRS Criminal Investigation, and U.S. Customs and Border Protection. The government's position was straightforward. The defendant had been a sworn law enforcement officer for 22 years. He had been a state trooper of the year. He had been a designated federal task force officer with the Drug Enforcement Administration. He had used the credentials he had been entrusted with to steal evidence, sell narcotics, accept bribes, and arm a convicted murderer. The conduct was not a single lapse. It ran for years. The corruption was not opportunistic. It was systematic, signed in his own hand hundreds of times, across hundreds of records. The defense argued for mitigation. They pointed to the back surgery. They pointed to the prescription history. They pointed to the legitimate medical origin of the opioid dependency. They pointed to the 22 years of service before the offense conduct began. They pointed to the family, the kids, the wife, the modest house, the absence of lifestyle proceeds. They asked the court to weigh the man who had earned the 2009 award against the man the federal investigation had uncovered. FBI Jacksonville acting special agent in charge. Hubert Reynolds had already given the public statement that would frame the case in the news cycle. Law enforcement officers who operate as though they are above the law betray the badge and the citizens they swore to protect, Reynolds said. This case exemplifies the FBI's commitment to holding public servants accountable if they violate the very laws they promise to uphold. Judge Berger considered both sides. She acknowledged the addiction. She acknowledged the service record. She did not minimize either. But she described the conduct in language that left no room for misunderstanding. The defendant had not just betrayed a badge. He had broken the chain of custody that the entire criminal justice system rested on. He had falsified federal documents under his own signature. He had armed a convicted murderer. He had put fentanyl and cocaine back onto streets in a city that was already losing people every week to those exact substances. And he had done it from inside the federal task force office that existed to stop precisely that flow. She sentenced him to 108 months in federal prison. 9 years, plus 4 years of supervised release. He forfeited the firearms. He forfeited the ammunition. He forfeited the proceeds tied to the offense conduct. He was designated to serve his sentence at the federal prison in Jessup, Georgia, with participation in the residential drug abuse program. His co-conspirator, James Darrell Hickox, had already been sentenced 3 months earlier, in January of 2025. Hickox had pleaded guilty to distributing narcotics, conspiring to defraud the United States, and tax evasion. The federal court sentenced him to more than 17 years. And then there was the damage that did not show up in either sentencing transcript. In Jacksonville, the state attorney's office quietly dropped the case against Anthony Christopher Gant and Diamond's Jonquil Ford. Gant and Ford had been accused in the 2020 shooting of a Jacksonville Sheriff's Office detective at a suspected drug house. The state attorney's office, asked to explain the dismissal, was direct. Only Hickox's testimony could establish the evidence that the house was a drug house, the office said. The case could have continued, but for these arrests. A Jacksonville detective had been shot. The state had filed charges. The case had been built. And then the federal corruption case took the testifying officer off the witness stand permanently, because no defense attorney in North Florida would ever again let a jury hear sworn testimony from a federal task force officer who had pleaded guilty to falsifying evidence paperwork on the same kind of investigations. The Gant and Ford case collapsed under the weight of the Earrey and Hickox indictments. The shooting of a JSO detective went unprosecuted because of corruption that had nothing to do with that night and everything to do with the men assigned to handle it. That is the part of this case that the sentencing transcript does not capture, and it is the part that the public statement from FBI Jacksonville hints at. Evidence room corruption inside a federal task force does not just steal product. It does not just betray a badge. It compounds outward through every case the corrupted officer ever touched, and through every case the system relied on them to support. A detective takes a round in a stash house in 2020. A trooper steals 1,000 pounds of marijuana between 2017 and 2023. A prosecution dies in 2024. The lines connect even when the cases do not. Joshua Grady Earrey will report to the federal prison in Jessup, Georgia. He will serve 9 years. He will complete a residential drug program. He will leave federal custody in his mid-50s. The plaque that named him 2009. Trooper of the Year is no longer on his wall. The badge is gone. The credentials are gone. The pension is gone. The paperwork he signed is still in the file. Every falsified destruction entry, every signature line, every certification that something had been incinerated when it had not. The system that was supposed to be unbreakable is still running, in Jacksonville and in every other field office in the country, on the integrity of the officers who handle it. It worked for the 99. It failed for the 1. And the cost of that one, measured in stolen evidence and broken cases and a detective shooter walking free, is the part of this story that no sentence can put back. This case was staggering, but the case on the right-hand side of your screen right now is somehow worse. Click it.